Today, something really important: counselling, confidentiality, and the law. Now, this puts fear into some students. Why is this such an important topic, Rory, and what do we need to know?
It's an important topic because when clients come to see us, they expect a degree of confidentiality. They don't want their information discussed on social media or in the pub or at the cinema or wherever people meet. They want to be able to talk about the issues in their life, safe in the knowledge that the person sat in front of them is going to keep their confidence. Now, that's the first point. Confidentiality isn't an absolute, and it cannot be guaranteed. So what we have to say, we proceed on informed consent. So what's informed consent? We tell the client what the basis of confidentiality is, and crucially, the exceptions to confidentiality. So a lot of people think that we keep secrets as therapists. We don't. We keep confidentiality, and there's a difference. And speaking solely at the moment within UK law, I mean, there's different laws in different countries. If you're in a different principality, a different country, suggest you check the laws that are applicable to where you're residing. But in terms of the UK, there are two things. One's called an example of legally obliged disclosures, and one is called examples of discretionary disclosures. Now, a legally obligated disclosure means that you have no choice. Under the law, you have to disclose if a client has mentioned certain things. So I'm going to give you three examples. The first is acts of terrorism. So in the very unlikely event, and I think we have to put some real world into this, it's very unlikely that someone's going to sit in a therapy room and say, I'm just thinking of doing some acts of terrorism. Very unlikely that would happen. However, there is a law that says that if someone talks about an act of terrorism, either I'm going to do that or I know somebody who's going to do that, then you're legally obligated to break confidentiality and report them to the police. And also, there's a second law that's attached to that. You're not allowed to tell them you've disclosed, which is probably quite a good idea. If someone's thinking of doing a terrorist activity, you don't want to be the person to tell them that you're going to tell the police. But also, the reason for it is that you shouldn't be tipping off someone who is conducting an act of terrorism, so you're not allowed to tip them off. The other is drug trafficking and money laundering. Again, two things you're probably hardly ever going to see in your practice. So drug trafficking, just to be clear, is someone with a big wagon full of drugs who regularly carries them along and sells them in bulk. We're not talking about someone who buys some cannabis on a Friday night or a couple of ecstasy tablets. What we're talking about is bulk movement of trafficking drugs, being in the business of reselling drugs. And the other is we have to abide by subpoenas. A subpoena is where a judge issues a diktat to an individual to say, you have got to do this. And you haven't got a choice unless you want to go to court and ultimately go to prison. What might happen is that they might want your notes, and you might say, I'm afraid I can't give them to you. And the police might issue a subpoena. It's a pretty standard thing. It's a bit of a game, really. Police may come and say, can we have your notes? And the therapist says, you know that I can't give you my notes. They say, get a subpoena, and you go, fine. They get a subpoena, and then you comply. It's just one of those strange dances in confidentiality that therapists sometimes have. And then we have examples of discretionary disclosures. Now, a discretionary is really the therapist's discretion. And shockingly, child protection and safeguarding, if you're an independent practitioner, so you're working on your own, is discretionary. Protection of vulnerable adults is discretionary, and risk of suicide or serious harm to self or others is discretionary. Now, I'm going to preface that by saying that when you contract with your client, you should be thinking about putting these to your contract. So your client can look at a contract and say, if I talk about child protection issues, or something about vulnerable adults, or harm to self or harm to others, then confidentiality be broken. The idea is that a client shouldn't be surprised or say, "You never told me about that," if you break confidentiality. If you're a student in practice, then speak with your supervisor. If you are writing an essay, then really the essays should be around legally obligated disclosures and examples of discretionary disclosures. Those are the two real areas that someone who's marking an assignment should look at. One final thing, I think, if you are students in practice, don't act impulsively without consultation. So before you think of breaking confidentiality, speak to someone, your practice manager or your supervisor. Just don't do it straight away. If someone says something and you go, "Oh, I'm going to have to break confidentiality," talk it through. Unless it's an emergency, someone actually says, "I'm going to leave here and take my own life." In that case, then really you've got to act immediately. But it is quite complex. And I think for those coming into training, it can feel very complicated and a bit scary, Ken.
Can indeed. There's a lot that you've covered there. I just want to put some brackets around everything that Rory has said. We're based in the United Kingdom. We're talking about the law in the United Kingdom when Rory is quoting where we need to break confidentiality. If you're outside of the UK, you'd want to be having a look at what are the laws that govern confidentiality for you and your clients. And there are many countries where child protection is a mandatory disclosure. So we're speaking only here in the UK on that one. And you started with this, Rory. I said, what's the reason for it? I'm going to chip in here and say we legally keep confidentiality because it is the law, and we have to break confidentiality when we are mandated to. But also one of the biggest reasons for complaint against you as a professional are around confidentiality. And it's not the breaking of confidentiality, it is the misconception that a client may have coming into therapy and thinking anything that they say within therapy is a secret, is kept confidential. And of course, most of it is. It's a cornerstone of therapists and client relationship. It builds that trust. But we have to clearly outline before we start the sessions within our contract and verbally, and gain informed consent. In other words, getting the client's signature and a date that they understand and agree to what we are speaking about. And it's interesting, in the news in France, the CEO and founder of an app called Telegram, which is a private messaging app, has been arrested and detained. And the reason for that is that there was messaging around drug trafficking and money laundering that took place on the Telegram application. And when the police investigated and asked for those notes to be handed over, the CEO said, "No, this is a private messaging platform. We're not handing that over." And he was jailed for that. And that is the end point of this. It's breaking the law if we don't work within it and break confidentiality where we must. And I guess there's misconceptions out there that may lead a client into thinking that you can speak about anything in therapy. And a television series that I used to watch called The Sopranos, and this was about a mafia family. And part of the formula of this was the mafia boss would go to his therapist on a weekly basis and get all the stuff off his chest because this was a confidential place. That is not true. Certainly not here in the United Kingdom. You couldn't do that. You may have studied and know this stuff, but without it being in a contract, without the informed consent of your client, with them knowing exactly where you need to break confidentiality, you can fall foul of the law, or you can get a complaint laid against you with your professional body because there was a misunderstanding about where that was. And there are certain agencies where, when working within the agency, they will have times that you need to break confidentiality that are not maybe reasons that you would in your own private practice, but they are when you're working within that agency, and that also needs to be taken into consideration because they'll have their reasons for why that is done as it's done, Rory.
Yeah, so check the law as it stands in the timeline you're in. Check the information. Go to your professional body's website, speak with your supervisor, speak with your agency, and check, because laws change.
Yeah, and a recent change which deals with informed consent is the information that we hold on our clients, just their name, their address, their telephone number, how that is stored. So it's interesting when we speak about consent and confidentiality, just the client's name and details are confidential, and we need to keep them and we need to protect them. So there's a lot to consider. And I think definitely a topic to ponder on. If you are a qualified practitioner, maybe time to get the old contract out and have a reread over that and just see that as up to date as it needs to be as the law changes and as the guidance changes.
Indeed, Ken. And I think it's all part of good practice.